welcome to Legal Basics with Sarah Law Global, and my name is Sian. We are still on the Intellectual Property series, and today we're going to compare the pros and cons, the advantages and disadvantages of protecting ideas either as confidential information or as patents. Remember, when we discussed patents, we explained that for patents, the inventor exchanges, reveals his original ideas in exchange for the rights of exclusive use of those ideas. So basically, the patent regime says, give me your ideas, reveal them to me, show me your processes, how you make your product, how you arrive at this thing that you're making. Tell me everything. In exchange of you telling me, I am going to ensure that nobody else makes what you make unless you allow them. That is a patent. For confidential information, we say, don't tell me. If you tell anyone, give them a non-disclosure agreement such that your information is safe. So now, as a person with original ideas or as a business, how do you go? Do you protect them as confidential information or do you protect them under a patent? So on today's episode, we will consider which one is better than the other. So number one, the first thing that you need to consider is whether your ideas are patentable. Now, you may have ideas that are very unique in your place of business. You may have ideas that are very unique in your country. However, you might not be sure whether somewhere else in the world, somebody else has registered that idea as a patent. Now, for patents, as we said, your idea must have three main ingredients. It must be completely new. Nobody has registered a patent in that name. It must have an inventive step, which means it's not obvious, and it must have industrial application. However, for confidential information, it could be over ideas that are patentable and the ones that are not patentable. So if you're not sure whether your idea meets the threshold for a patent, then you might be safer protecting it as confidential information. Secondly, you need to understand the patent law in your country or in your jurisdiction. Jurisdictions are different. Some jurisdictions allow you to put your ideas to use and even demonstrate them or reveal them once you have filed an application for patent. Some jurisdictions do not allow you to reveal this information at all until your application has gone through and your patent has been registered. So, depending with the jurisdiction or the country where you want to register your patent, you're going to look at the threshold for revealing your ideas. Is it the application of a patent, the fact that you have filed, or is it the fact that you have already been registered? If you exist in a regime that does not allow you to use these ideas or demonstrate them before you have gotten a full registration for a patent, then you're safer protecting them as confidential information until you decide that you want to now get a patent and then reveal them. Third, you need to look at the strength of protection. Now, a patent gives you very strong protection for 20 years. So, when you take a patent and you register it, it means that nobody else can register a patent over your idea. Whether this person sat in another continent and had exactly the same idea as you, the fact that you have registered your patent stops this person from using that idea or that process. So the protection is extremely strong. Even if somebody mistakenly or accidentally or independently came by your idea, the fact that you have registered stops them from applying your idea except with your express authorization. However, for confidential information, you could keep your ideas as secret as possible. However, if somebody else comes by the same idea independently through reverse engineering or through discovery, then your secret is out and you cannot go and stop them from applying that idea. So depending with the strength of your ideas, now when you go the patent way, you get stronger protection. When you go the confidential information way, you get weaker protection because it allows somebody else to apply that idea. Fourth, you need to look at the term of protection. For a patent, your ideas and the fact that you can only exclusively use them, or somebody who has been given an express consent by you for patents, you can only use the patent for 20 years. After 20 years, other people are allowed to apply your ideas. However, for confidential information, so long as the secret never gets out of the hat, you can protect it forever, so long as you keep it secret. So depending with how much longer you need your idea to be protected, then confidential information will ultimately give you a longer period of protection than a patent, because a patent will expire after 20 years. Lastly, and number 5, you need to do a cost-benefit analysis. So for confidential information, you will look at how much your business or you as a person or your resources allow you to protect that information and keep it confidential. Now for a patent, you will have to look at the money or the cost of hiring patent attorneys, of making an application, of paying for examination, and maybe if there's objections. And then once you compare the cost, you're able to see which is better for you and better for your business. I hope that this broadcast has been useful to you. Please write to us with your queries at cyrillowglobal@gmail.com. Please, if you like this video, like, subscribe, and share with your family and friends. We are hoping that at the end of this intellectual property series, you will be able to all come up with wonderful ideas and you will be able to protect them, because intellect is property. Bye-bye. Take care of your family. Stay blessed.